ASIC, and we'll go straight to questions. Go to the Deputy Chair, Senator Bragg.
Thanks very much. Welcome back. What is your view on crypto, Mr. Longo? I believe in the past you might have said it was nonsense. I've also got a quote here from you saying it was the bigger fool theory, but I wonder if those are misquotes or whether that is your actual view about crypto.
My job is to administer the law as it is. Part of that involves warning consumers about trading or indulging in activity that's clearly highly risky, speculative, and about which there is ample evidence that losses can occur for no good reason. Putting that to one side, under the existing law, the cryptocurrency activity is regulated. If it's a financial product or service, then the law has been for years, if it is, you need a licence to do that activity. And we published an information sheet years ago, and I think there's been a bit of misapprehension and confusion recently about ASIC's position. I mean, I'll pass Alan Kirkland in a moment, who's personally attended a lot of the consultation meetings. But I think the key points are we're technology neutral. The law has been like that for many years. Secondly, our approach to regulation of crypto is in fact no different to our approach to regulating any other financial product or service. We publish a lot of regulatory guidance, information sheets on a wide range of financial activities, and they get updated. So I think so my broad position is I have warned consumers about this activity. It's clearly highly risky. But our job is to administer the law the way it is, and so and we're technology neutral. So the only other point I would make is that the recent work that ASIC has been doing in this space is actually responding to various voices in this sector who are looking for more certainty in their business. So I think we're right in the middle of a consultation. We're open-minded. We're doing our best to administer the law to best effect. So I'll hand over to Mr. Kirkland, who's personally been in...
Before you do that, because I'm more interested, you're the head of the agency. So it sounds like you don't think it's nonsense.
I think it's a highly speculative activity. I do have personal views.
Well, you're entitled to your personal views, but you're also the head of the agency.
That's right.
What you say carries more weight than if you were doing a different job.
Well, I don't think I can be any clearer than to say to the general public that this activity is highly speculative, it's risky, and should not be undertaken lightly. Now, that doesn't mean it's illegal or it's prohibited. And as the regulator, it's my job, as I've done across a number of asset classes, and indeed in this private public markets paper, we've expressed views about private and public markets and the need for transparency and data. And in the crypto space, it might very well be said that there's a greater need for transparency there as well. So I don't think my views about the riskiness of this behaviour, I have no intention of withdrawing them. Secondly, I do intend to apply the law as it is. And if there's financialisation of this activity going on and it's regulated, we will regulate it. Now, if the Parliament wants to amend the law or revise the law... You mean enforce? We will administer the law as it is, and that includes licensing, and it does involve enforcement action. And we have a number of cases in the courts where we have taken action and been largely successful. So I think it's really important that we dispel this confusion. The ASIC will continue to administer and enforce the law as it is in connection with this activity. We're not policy makers.
That's right.
Now, if the Parliament wants to revise the law or amend it, then of course we will. Well,
you could
do
be.
that.
If you ran for Parliament, then maybe you would be. But right now, you're not. That's right. So when you talk about it being highly risky, you're talking about it through the lens of an investment, aren't you?
I'm talking through the lens of a retail investor. Yes.
Yeah, I figured as much. So you're not necessarily impugning the value or virtue of disruptive ideas. You're talking about this through the prism of
if there's one thing I'm pro, Senator Bragg, is technology and innovation.
Well, we agree on that.
Absolutely agree on that. But it's part of my job we are technology neutral. But part of my job as head of the agency, and I do accept to be reminded of that, is it's part of my job to call out activities that are causing harm. And so there's some crypto-related activities that have led to very significant losses for retail investors. And they need, all I'm saying to the market is be careful. Be careful.
Yep.
Yeah.
So, I mean, in light of your comments that you are a law enforcement agency, which I very much welcome, what is the outcome you're looking from publishing a paper on private credit?
We are publishing a paper on, that includes private credit. So what this paper is about, stepping back, is about our markets in general, private and public markets in general, and in particular what's happening in our public equities markets, what's happening with the investments superannuation are making, in particular, and the impact of that on the stock exchange and in the private market space. We're concerned. This is all in the discussion paper.
But are you agitating for any policy change? Are you using your position to agitate for the Parliament to do something? That's my question.
Okay, fair enough. We did this paper for several reasons. One is to shine a light on a section of our markets that we believe is lacking transparency at the moment, and as a national markets regulator, I'm concerned about that.
Yeah.
So one thing we would be asking Parliament for, and have asked Parliament for over the years, is more recurrent data gathering powers, and for other we can be more specific on notice, and other, I'll call them reforms. And by the way, this would only line us up with what's going on internationally. We're actually behind in this space, is to give us greater transparency. This is not about, and I've made this very clear, re-regulating the private market space. It is about understanding what's going on there, and secondly, being very open-minded about whether there are, it's actually the other way around, Senator, whether there's aspects of our current regulatory settings that are impeding these markets, in particular the public market. So that, I think that we've made that very clear in the paper. And the other thing, in fairness, that I've made clear in the paper is that some very serious players like Larry Fink and others, they're worried about what's going on in these markets. They've become a bit frothy, and they're looking for more data and transparency. So part of what we're trying to do here is do the work, and by the end of the year, hopefully have something sensible to say about whether there is a need for any additional regulatory interventions, aside from the data gathering, which I'm morally certain we do need. But I'm not so convinced that we need more regulatory interventions in the private space, particularly as, and I'll stop there because this is a big subject, we're very open to hearing from market participants about what they're doing to maintain standards in this area. What we're interested in is keeping Australia competitive, attractive, and having an eye on risk. They're the key things.
Thanks, Mr. Longo.
Senator Barbara Pocock.
Thank you, and thanks all for being here. Just on that front of governance, I haven't read yesterday's paper, but I'm just interested in if you have any thoughts in relation to governance. You point to the changing dynamics between public and private markets with that growth in private capital markets. What are your reflections on the different levels of governance in those two different kinds of investment categories?
There's what's often raised in the public space is that the levels of governance are actually too high, that our expectations of directors of public companies are too high, it's too burdensome. And I get some feedback that those boards are spending far too much time worrying about compliance rather than worrying about growing the business, and the balance isn't right. Now, what this paper does is our preliminary view is, I think that view has to be respected, that there is, and in fact that's one of the reasons we're doing regulatory simplification and listening to directors, but we don't think that's the main reason why we're seeing a patchy listing history on the ASX. We think it's part of the story, but we don't think it's the main driver. And as I've said, I think we are asking and inviting the ASX to take a more proactive approach with its listing rules to see whether there are things that can be done to make the public markets more attractive. Now, as the regulator, it's not my starting position to prefer one over the other. We need both. One supports the other. And these markets are crucial to our economy, and there's a lot going on internationally in terms of, for example, non-bank financial institutions. And this is going back to Senator Bragg's observation about private credit. We're coming from a relatively low base in Australia, but it's growing very quickly. And there are issues about valuations and disclosure and potential risk being transmitted from one to the other. So at the moment, what I'm really calling for is saying, look, everybody, this is a really important issue. And there are a number of things happening at once. We have the impact of 4 trillion odd Australian dollars looking for a place to invest. We'll call that superannuation. But the Australian Stock Exchange, between a quarter and a third is super. And then we have these other developments. So I think the paper really is a significant piece of work in sort of calling out these key themes and saying to everybody, you know, we all have an interest in getting this right. Everybody literally has an interest in getting this right.
If I can continue then around the question of governance, you may be aware of the large body of research internationally about how more gender diverse boards are associated with higher returns. There's research out of the US, out of various European countries. Bloomberg Intelligence recently drawn attention to a 2 to 5% higher return than companies with fewer women on their boards. And of course, diversity, equity, inclusion issues are on the international agenda. Today we hear John Deere in the US, shareholders have rejected a reduction in commitments to DEI, and this is occurring in other places as well. So it's a controversial issue, important to governance. Do you see a connection between diversity on boards and in senior leadership and performance?
I think I certainly support diversity on boards, and I'm not going to comment on all the research. I think it's an area which seems to have attracted a lot of controversy in more recent times, but as a general matter, my views about board composition, I would step back even further and say, yes, absolutely, diversity on boards is really important, and ASIC encourages diversity, as indeed we do in our own institution. The only other thing I'd say about board composition, and I think it's as important as diversity, is science in the boardroom. So you'll be hearing me say a lot more about that. The diversity we're looking for on boards needs to include that as well, that we have directors. Can you explain?
Sorry, I missed the word you used.
Science.
Okay.
Yeah. And so we've had a lot of discussion. We've just been touching on crypto and the extraordinary underlying technologies that are summoned by that idea. We have AI that is just really becoming more and more significant from a governance perspective. Of course, I think diversity, gender diversity in particular, is really important. But from my perspective at the moment, I'll be talking a bit more about this in a few weeks at the AICD forum, is sort of stepping back and saying, what sort of board composition do we really need to face all these challenges of the future? It includes diversity, but you'll be hearing me banging on about science as well. So
you're talking about diversity of knowledge as well as diversity by
and experience
and other characteristics.
Yeah, diversity in its broadest sense.
Yeah. And coming to your own organisation, do you implement and follow through on equity and diversity policies within your own organisation? I'm assuming, of course, all appointments would be on merit, but making sure that established cultures and practices of recruitment, promotion, and so on reflect non-discriminatory and inclusive practices.
I think we're passionate about it. In fact, I might ask Kate O'Rourke, because all the commissioners are involved in diversity and inclusion efforts of one form or another internally. But I know Kate in particular is passionate about it. I'll ask Kate to say a few words.
Thank you, Senator. So ASIC does have a diversity council, which I'm pleased to chair, and which includes, as well as other commission representative and executive representatives, the leaders from our staff of 6 different diversity committees that we have. So Women in ASIC, Parents and Carers, Multicultural Committee, Access and Inclusion, Reconciliation Action Plan, and our Rainbow group. So we have those 6 staff-led and staff-run committees. Obviously, all the staff do their other jobs as well, but are passionate about using activities within our organisation to enhance how we run as an organisation. We have events and very practical initiatives to help ASIC run even better.
So if we suddenly had a leader federally who said DEI is off the table and I want all DEI appointments sacked and removed, as the executive order does from Donald Trump in the US, from what you've just said, that would be a very small list of sackings in your organisation, given, as I hear, you've integrated the practice across your leadership. Is that a fair assessment?
The committees are staffed by people who are, have employees of our organisation. So that's how those committees are run. Yep.
Great, thank you. I want to go back to ASX governance. You'll be aware that the ASX Governance Board, I think it's called the Corporate Governance Council, thank you, has recently dropped or paused its proposed revamp of diversity, equity and inclusion reporting measures. I understand they've been through 5 rounds of amendment as a result of pushback from 4 business groups, including the Business Council of Australia and, sadly, the Australian Institute of Company Directors. Does ASIC take an active interest in Australian companies and their DEI policies?
Senator, the first part of your question, we're not part of that process. So the ASX Governance Council is independently chaired. It's actually a consensus-driven body. And if my memory serves me, we have the 4th edition of the principles currently in operation. And they, as it turned out, they weren't successful in coming up with a 5th edition. Of course, we're interested in what happened and what didn't happen, but we're not at that table. It's really entirely driven by the ASX and that council.
So do you have a view about that scaling back of creating a reporting obligation?
Well, I think that the press reports, I think it's very important that, for my purposes today, I've been watching what's going on, but from my perspective, the 4th edition is there. It remains operational. Our job's to administer, as I said a minute ago, the Corporations Act as it is. We have an enormous body of case law that talks about what our expectations of directors should be. We work closely with industry organisations. So from my perspective, it's an interesting incident and a disappointing one, because I think there were high hopes right up until recently that there would be a 5th edition. It just didn't work out. So I'm not sure what's going to happen now, whether there'll be like a cooling off and maybe 6 or 12 months from now there'll be another attempt at getting a 5th edition off the ground. From my perspective, I'm not sure I could take that much further. I don't know if that's helpful, Senator.
Do you, as ASIC, see an area of potential conflict where companies with a significant presence in Australia that have scrapped their diversity commitments might be breaching Australian law? One such company we've heard say publicly, for example, Accenture, does an enormous amount of business across our economy, including in the public sector. Do you see that as a conflict where a company says they're walking away from diversity and inclusion and non-discriminatory practice in the shadow of Trump? Is that a concern to you?
Well, it's certainly this unfolding situation is a concern to anyone who's worried about the highest standards of corporate governance. I think I can't speak for the US. I think we'll have our views about the US. But speaking for Australia, our own country, I think our values, our principles are well embedded in our institutions and in our law. Now, some of that are actually values and principles. They're not to be found in the Corporations Act. So I think it's we have a particular culture, a way of doing things in Australia, and I think we should all be, I think, proud of that. Now, there may be particular entities, some of them may be listed. Accenture, for example, I don't think is a listed entity. It's like a partnership. And so those entities will have to take responsibility for what they say about their practices and approach to this topic. And I think we're all going to be interested to see what happens in the next 6 to 12 months, to see what walking back there is from this important topic. Now, the other part of that is that from an ASIC perspective, is that breaching the law? That's a different set of issues, I think. If you're looking at it from a Corporations Act lens, then I think it'd be very fact sensitive. I don't think you can sort of say, oh, the Corporations Act requires diversity in the boardroom. I don't think you could put it as bluntly as that. I think that it's more likely to be more subtle, where if you're doing business with the Commonwealth, then the Commonwealth won't want to be doing business, I'm just being hypothetically, won't want to be doing business with an entity that doesn't subscribe to these values and principles. I can see that way of enforcing, if I can use that word, this approach. But as far as the Directors' Duties provisions of the Corps Act are concerned, they're very broadly drafted, they're very general. And as far as I'm aware, and I try to keep on top of the case law here, I'm not aware of any case law in Australia that sort of directly says, oh, you know, you've broken your director's duties because you haven't encouraged a diverse work environment. Now, I think that we have a lot of employment legislation. We have other ways, I think, other hooks of approaching that issue. So I know that sounds a bit general, but at the general level, well, of course, we're very interested in high standards of corporate governance, and that includes diversity.
So there've been...
Senator Pocock, I did neglect to advise senators that I'd go in 10-minute blocks when we return from the lunch break, and you're pretty well into another one. So yeah, a final question, that'd be great.
Last one, and it's going over the same territory in a way, but there've been a litany of corporate governance failures in recent years. I won't go through them, that for many sort of point to the need for a new set of principles for listed companies, and the failure of that governance board at the ASX to come near to agreement on rule changes really points to the failure of our corporate leaders, the governance group of our biggest corporations, to come to navigate a way forward and establish a stronger commitment to things that are connected to good governance. Do you see a role for ASIC in solving that dilemma and in finding a more positive way forward on diversity? Well,
the ASX Governance Council, we're talking about the ASX Governance Council, that's really a governance council there to support the ASX, and it's by consensus. Now, can I just say that this is an area that tracks a very broad range of views, and and from an ASIC perspective, we try to approach issues when things go wrong in an objective way based on the law as it is, and we try to apply some judgment. Now, I'm not trying to avoid your question. I think there's all sorts of reasons why companies fail. Their business model fails, there've been problems in the boardroom, any number of reasons. And so I'm not sure I can generalise if that's the right way of putting it to answer your question, other than what I've already said.
Thank you. Senator Cox.
Thank you, Chair. And can I thank you for your work, firstly.
Thank you, Senator.
And the conversation this morning, particularly around insider trading and increase in your workload. So the first question is, given that it's been increased by 20% investigations, has that been an increase for resources in any way to assist in any of that?
Well, I'll ask Deputy Chair Court to provide some of her own observations as Chair of the Enforcement Committee. But when we approach enforcement, I'd like to talk about the machine. The general public sees the output, sees the court cases, but we spend a lot of time and energy thinking about how to investigate more quickly, more efficiently, how to work together more effectively, how to choose matters to best effect. So because we have limited resources, so how we select matters is very important. I'm going to hand over to Sarah Court for a minute, but I cannot leave this opportunity to say that we have to invest in technology and data. We're doing our best within our existing resource remit, and I think some of the gains of the last 12, 18 months is a better use of technology. But I think if we are to remain an effective law enforcement agency and keep up with most issues in our lives these days, all have a connection of technology. When members of superannuation funds don't get what the services they require, the root cause, technology. When banks let their customers down, a lot of the time, the root cause, technology. We have to understand AI, we have to understand what's going on in crypto, we live in a world of data. I said earlier, I want to try to understand what's going on in the private markets. Data. So we will be even more effective as a law enforcement agency if we invest more in data and technology. Sarah? No.
Thanks, Senator. In terms of the increase in work, as I think Mr Longo said in his opening remarks, we have significantly increased our new investigations in the last financial year and our civil penalty proceedings. In fact, I'm just looking at the statistics while Mr Longo was talking. So in the last financial year, we increased our new investigations up to 168, and that's the highest number of new investigations we've had over the last 5 or 6 years. That's been a very deliberate effort by us. We had and you weren't on the committee, Senator, at the time, but in previous appearances we've talked at length about the organisational restructure that Asic underwent a couple of years ago, and one of our real aims of that work was to try to make sure that we could move matters through our agency more quickly than they had managed to get through the agency in the past, and we get a very high volume of matters, complaints, referrals of misconduct that comes to us day in and day out, and one of the hardest jobs for our staff is to look at all of those and assess those reports and work out, well, you know, which ones should be elevated for an investigation, which ones should be with another agency, which ones will we not get evidence to support the various issues. And so what we are cautiously hoping that we are seeing is now, moving into the where we are now, the results of some of that hard work that's been done over the last couple of years. Having said that, I just make the only caveat that numbers like this, of course, move up and down year by year, and one of the other challenges that we have is when we have large numbers of new investigations that work their way through the enforcement machine that Mr Longo's talked about, many of those will end up before the courts or with the Commonwealth Director of Public Prosecutions for criminal prosecution. Then our teams have a lot of work to do to support those matters through the court process. So it's not like we get to a certain point, we hand it over and our work here is done, we'll start on the next investigation. We have very large teams of people that are involved throughout the court process in liaising with witnesses and drafting affidavits and taking statements and compiling evidence and working with counsel. So they do a terrific job. We have a lot on, but we're having really pleasing results at the moment in our enforcement capacity.
Can I ask then, Ms Court, given that data is quite powerful too, and I think feeding into my colleague Senator Pocock's question around corporate governance, are we able to see any trends from that data? I know that, like 168 is quite a high volume, but trying to look at what those trends are in the data and where they're coming from. And I think, Mr Longo, in your opening statement or in a question to in response to Senator O'Neill, you talked about particularisation, you talked about looking at it case by case. But essentially, if there are particular markets or there are particular areas in which there are data trends, is any of that that you're able to table with the committee, or is it publicly
There are
available?
several levels to the data story. We, in fact, Deputy Chair Court alluded to a couple of them already. We get data through reports of misconduct around 10, I'm guessing around 10,000. And then we get data from the Australian Financial Complaints Authority, from external dispute resolution schemes, internal dispute resolution data, and there's the how can I forget, the reportable situations regime also produces a lot of data points in terms of reportable situations. So when you step back from all that, you say, well, what's ASIC doing with all that data? And the answer is we have a data lake with a range of technologies and processes that try to interrogate that data. But the short answer is I think we need further investment in our capability there, to be really frank. We've made submissions to government and indeed to committees like this about it. But the other answer to your question is we do our best to draw conclusions and inferences from that data about where the emerging problems are and what where we should be putting our attention. So it does inform our enforcement work, but in particular, it also informs our regulatory work, because not every problem or issue that the data is telling us is something we can litigate. It might eventually be, but in the meantime it contributes to our regulatory guidance, the way we think about problems, the way we do thematic surveillances, our surveillance work. So that's the... If we know what's going on, we're able to focus our limited enforcement and surveillance resources to best effect. That's the key. You know.
Okay, thank you. That's very helpful. I haven't even got to my question yet, so sorry, Chair, that I originally came in with. And I hold the trade portfolio, but I also hold resources as well. And given that approximately 95% of foreign-owned companies are in the oil and gas industry operating within our markets, particularly in consortiums and alliances, what would be the process? And I'm, I want to sort of do the 101 for people who are watching here today around directors buying shares that what may be seen to be insider trading with the information as Senator O'Neill talked about this morning.
Yeah.
What is the requirement, I suppose, for a director?
There's no general legal, that I'm aware of, requirement as to how companies manage this issue, but a well-run public entity, they all have procedures and policies that deal with this very issue, and there are trading windows. I think so there are times when you're allowed to trade as a director, right. And depending on the policies and procedures of the particular entity, you may need to get approval from the Chief Compliance Officer or from the Chair. The various ways of tackling the issue, but broadly speaking, a well-run company will have well-developed governance and compliance procedures around what circumstances in which a director in particular can trade in the shares of the entity that they're a director of, which is obviously very sensitive.
So a company director, so just hypothetically, without sort of doing the thing we did this morning, but that a company director with a company that's not doing so well then increases their shares, buys into it. There are milestones that may be happening in projects outside of that. They have access to some of that information.
Yeah.
Are they generally the red flags?
Well, this is where we get to continuous disclosure. If it's a publicly listed entity,
So how does that work with an international market, though? So if this is listed on AIM and the London Exchange...
Most markets will have disclosure rules.
Yep.
So in the US there's Reg FD, full disclosure. The Brits have their rules.
But how does that when they're operating in Australia?
They're operating in Australia and they're listed here. If their securities are listed here on the public exchange, then they're under an obligation to continuously disclose material information that affects the price of value of their securities. So the idea in a nutshell, if you're a director of one of these entities in Australia, is that so long as your company is strictly complying with those obligations, then in theory at least, when the director trades, he or she hasn't got any advantage of everybody else because all the material information should be out there. Now, as I say, different companies have different approaches to this. There are some that are quite conservative and they'll only allow their directors to trade in the securities of that company around the announcement of their results, for example. Right. You've got like little windows, they're quite strict. Different companies approach this differently. And then, of course, there's the staff. So we've been focusing on directors, but the same policies, sort of not necessarily the same policies, but the same problem applies to all the staff because and senior executives because they've all got access to information as well. Yep. So this issue, as I say, it's a well understood risk in public companies, and my understanding is they've all got policies and procedures that deal with it.
Okay. So my final question, Chair. Thank you. Is there any relationship or arrangements that exist, given that there's 95% of those foreign-owned companies that are operating here may have securities and are doing whatever it is in compliance in that? I know that there is a Foreign Investment Review Board that exists. What's the relationship between ASIC and the Foreign Investment Review Board?
We don't do... I'm aware of the work of FIRB. Their job broadly speaking, is to approve transactions that involve foreign investors and attract certain thresholds and caps. I'm not that familiar with their work.
But there's no...
Yeah, there's no... I don't know whether any other commissions have any...
I think the Foreign Investment Review Board procedures include gathering of information, and information that's gathered might include ASIC generated or information.
So we might help
not,
FIRB make their decisions.
Right.
But
there's no formal arrangements, is that right, Mr. Long?
No, as Commissioner O'Rourke says, FIRB has its own capability to gather its own, has its own powers and protocols. So if FIRB came to ASIC and said, look, we really need some help to understand this corporate structure, or what do you know about this entity? We're looking at this transaction. Has it come to your attention? Then I don't know how often that happens, by the way, but if requests like that would obviously...
Or if it's ever happened, right? Like...
I suspect it would happen from time to time, that we're asked for what we know about a particular entity. And by the way,
provide on notice whether it actually has and under what...
No, we can go back on notice, but some of those requests might just be interrogating our systems. They may not involve a phone call or a meeting or anything. ASIC has a lot of data of its own. Some of it's available to the public, for payment of a small fee to the Commonwealth, or it's available to the official family. So my guess is FIRB probably has some access to our database through that route as well, under our legislation. 627, I think, is the gateway. But we can go back on notice and
that'd be great.
tell you a little bit more about that.
Maybe Treasury could take that into consideration too, Minister.
Thank you, Senator Cox. Senator Smith.
Thank you very much, and thank you for your participation. Thank you also for the speediness with which you responded to my recent correspondence in regards to add-on insurance. And I'll just ask, with the Chair's permission, I'll just ask that AFCA's letter to me in regards to similar issues that I raised with them be circulated for the benefit of the witnesses and senators who might be interested. Oh, Chair, I just want to table this letter that I think...
Yeah, just pass it over to me and I will do so.
Oh, yep. I think you might already...
Oh, sure. All good. Senator Smith.
So I'll just start with your correspondence first. In your letter to me on the first page, you say that we, ASIC, took steps recently in response to concerns raised with us about AFCA's approach to the lodgement of complaints about mis-sold add-on insurance. Where did those concerns come from?
Thank you, Senator. I vividly remember the Commission meeting where we looked at this issue very closely. What I'm going to do, if it's okay with you, I'm going to ask Commissioner Kirkland, who's spent a lot of time engaging with AFCA and with third parties on this very issue. So I'll ask Commissioner Kirkland.
The committee tables the letter from David Locke of AFCA. Yes, the committee tables the letter.
Thanks, Senator. I believe we first became aware of these concerns through correspondence. Certainly, I first became aware of these concerns through correspondence from a law firm representing a firm known as Clamo, which I understand to be a business that submits complaints to AFCA on behalf of some consumers.
And when was that first raised with ASIC?
That was in December, is my understanding. December 2024.
2024. And when I read this statement in your letter, I took it to mean that there were a variety of concerns raised with ASIC. So were there others that raised concerns with ASIC about AFCA's approach?
To my knowledge, it was only that law firm, and it's possible that the firm may have raised the firm that was represented by the lawyers may have also raised some of those concerns directly, but I'm not aware of any other stakeholders raising concerns of that.
So then,
issue.
Since December 2024, what has ASIC done? How has ASIC engaged with AFCA? How many meetings, for example? Who have you been speaking with?
So we have had some conversations with AFCA. There will be some conversations that would have occurred at officer level that I've not been part of. I've personally been part of 3 conversations with AFCA, 2 conversations with the CEO, and another meeting attended by a range of ASIC and AFCA staff, including the Deputy Chief Ombudsman from AFCA. Those were meetings which we discussed AFCA's proposed. We discussed AFCA's proposed approach to this issue and some changes to its approach that AFCA was considering.
So when was the final meeting between ASIC and AFCA which agreed the extension of the date from the 4th of February to the 30th of June?
In relation to the latter part of that question, Senator, I should say there was never an agreement as such. There's not a requirement on matters like this for AFCA to seek ASIC's agreement.
But obviously there were discussions and negotiations, and there was obviously, or was AFCA considering an extension to the 4th of February deadline prior to the correspondence from the law firm in December 2024?
I think you would need to direct that question to AFCA.
Did you have any impression from AFCA that they were considering an extension of the 4th of February deadline when you started engaging with them on or around December 2024?
In my dealings with AFCA, the possibility of an extension was first raised in early January 2025. And again, just to ensure I'm being as accurate as possible in responding to the question, Senator, I wouldn't characterise those discussions as negotiations because, as I said, there's no requirement for us to reach agreement on these issues.
Your letter makes it quite clear in terms of ASIC's approach here. So why is a deadline necessary at all?
This is really a matter for AFCA, Senator. AFCA does have rules that already establish the notion of a deadline in that, in general, in order for a complaint to be considered by AFCA in relation to any issue, the complaint needs to be made within 6 years of the consumer becoming aware or it being reasonable for the consumer to have become aware of the loss that they've suffered or the harm that's been caused. So there is a deadline that's established in the AFCA rules, which I understand to be broadly accepted and supported by consumer groups and industry groups because it, I think, perhaps strikes a balance between offering redress to consumers but also allowing the scheme to operate efficiently, noting that it's industry funded. In this case, it's entirely a matter for AFCA to determine if it was going to apply a particular approach in relation to these types of complaints. It's very clear that it's not intended in the legislation that ASIC wouldn't get involved in those sorts of decisions. Although, as I think we said in our correspondence to you, where stakeholders raise concerns, significant concerns about AFCA, we'll often have conversations with AFCA to put those concerns to them. And it's then a matter for AFCA to consider whether it wants to make changes to its approach.
Yeah, that's exactly what your letter says to me, correct. So when you began your discussions with AFCA, also in the discussions with AFCA since you received that letter from the law firm in December 2024, what other matters have you discussed with AFCA in the context of the mis-sold add-on insurance? So time frame for lodgement or deadline for lodgement is one element of your discussions?
That is correct. That was an issue that was raised by AFCA, to be fair. So we did not ask AFCA to consider a change in deadline. They, as part of those conversations, volunteered that was something that they were considering. We did discuss with AFCA, we wanted to understand their reasons for suggesting that they would not, in general, consider new complaints in relation to add-on insurance sold before early February 2019 after a certain date in 2025. So we wanted to understand AFCA's rationale, and in the course of our correspondence with AFCA and our conversations, it became clear that there were a broad range of circumstances that AFCA was considering. So they had referred publicly to the issuance of or the publication of the Financial Services Royal Commission report, but it became clear that there were a broader range of factors on their minds, such as the various work that ASIC had done over time to raise awareness of this issue, including some significant reports we'd released, the campaigns by consumer groups, the degree of media coverage over a number of years. And so that was one of the sets of issues we discussed with them, that is, if there was a broader rationale for I guess, not hearing new complaints after a certain period of time, it might be better to articulate that more clearly in the fact sheet that they publish for consumers and for the industry. So that was the other key issue that we discussed in those discussions.
So then you came to an agreement or an understanding around the use of special circumstances? Or did the special circumstances pre-exist as an AFCA consideration?
So once again, Senator, I wouldn't characterise it as an agreement. These were issues.
The discussion, I said. I mean,
in the course of discussion, AFCA already had provisions in relation to special circumstances in its fact sheet. One of the changes that they told us that they were considering making was to better explain the special circumstances provisions and I guess the right of consumers to make an argument that there were special circumstances that would mean that their complaint should be considered.
do you think that the balance is appropriately struck between, the responsibility for banks who sold the add-on insurance, and then the balance between that and the consumer's responsibility to bring forward a claim?
Ultimately,
is the balance appropriately struck? You see,
look, that balance is one that we're conscious AFCA has to apply all the time. So I would say ultimately that's a decision AFCA has to make. That is clearly a decision for AFCA under the legislative framework. And we acknowledge where they landed on that. But we in our dealings with AFCA, we are always conscious that they're trying to strike a similar balance, that balance between offering access to redress for consumers, but also managing the costs of the AFCA scheme, which are borne by a range of industry participants, large and small. And at the same time, we're conscious that both AFCA and Asic at times hear concerns about when AFCA needs to increase its fees to members. So AFCA is often having to balance those considerations, and that's something that we acknowledge in our dealings with AFCA.
So you are aware that...
Sorry, Senator Smith, I am interrupting you, but I'm doing that for some housekeeping in order to say that the committee has decided to release the Productivity Commission. Senator Smith.
Thank you very much. You are conscious that the number of complaints has been rising. Discussions with AFCA, you obviously took an interest in what is their experience in terms of the number of claims that are being made.
Is this in relation to the number of complaints in relation to add-on insurance in particular? I don't have that in front of me, so I can't confirm that for sure. But I know we certainly did look at the number of complaints as part of our conversations with AFCA. I might just add, just to correct an earlier answer as well, Senator, when you were asking about the range of issues we'd covered in those discussions with AFCA, the other issue that came up was the degree to what AFCA might do to publicise the changes that it was considering making to its fact sheet, and AFCA said that it was planning to do some more work to make consumers aware of those changes.
Does ASIC have any responsibility in sort of raising consumer awareness around this matter?
It's not something that we would normally do in relation to a matter like this, Senator. We would see this primarily being the role of AFCA to raise awareness of the ability to make complaints, particularly where it's considering making a change to its arrangements.
Mm-hmm. So in your letter to me, you identify three dot points that you preface those dot points by saying, following our engagement with AFCA advised ASIC that it intended to do .1, .2, .3. Is AFCA required to provide you with any reporting of its fulfilment of those agreed outcomes? I don't want to call them agreed outcomes. Are you monitoring AFCA's implementation of those three agreed outcomes?
AFCA is not legally, to answer your question technically, AFCA is not legally required to report on those changes that it determined to make.
They're not formal undertakings, for example?
No, that's right. But we do engage with AFCA regularly at all levels, and so I would fully anticipate that as part of those engagements, many of which I'm involved with, we will be asking AFCA for an update on how it's going about those activities.
So so between now and the 30th of June, is there a program of engagement between AFCA and ASIC generally, not necessarily on this particular matter?
We have a series of scheduled meetings, so I arrange that they happen on a regular basis at officer level. Although I don't have any scheduled, I would typically meet with the AFCA CEO at least once within that period. And at least once a year, the Asic Commission meets with the AFCA board, and I just would need to check whether that meeting is due to occur within that period.
So, would it be correct to characterise the 30 June deadline as locked in?
My understanding is that AFCA has now established a new approach and communicated that through a fact sheet. But as noted earlier in this discussion, that includes a special circumstances provision. So consumers have the ability to indicate whether they believe the special circumstances that still mean their complaint should be considered after that point.
Is there anything in the AFCA rules that ASIC is aware of that would prohibit a further extension beyond the 30th of June?
I'm not aware of anything that would prevent AFCA from making further changes to the fact sheet that it's recently revised.
Great, thank you. Thanks very much for your cooperation.
Thank you, Senator Smith. Going to, Senator O'Neill.
Oh, thank you. Thank you very much, Chair. I'd just like to go to a case, I think, that gives demonstration to insider trading and the intersection between public service and information movement in and within the public service and its potential to be engaged by somebody outside the public service with knowledge to have an impact in the market. And the case that I'm referring to, and I'd just like to table a document, which is an article by Helen Vines and court reporter Peter Carlion, dated the 12th of March 2015. That will come to you shortly.
The document.
So I see Mr Savundra has joined us, and this is probably in the time when you were the General Counsel, if I recall.
Senator, for the Hansard, Chris Savundra, Executive Director of Enforcement and Compliance. I think the case you're about to refer to is when I was leading the markets enforcement team at the relevant time, so prior to me being the General Counsel.
But you have knowledge of the matter?
I do.
Wonderful. Okay, so if I can put it in this way, two mates at a party in around 2013 decide that they are going to share some information and make some money. And there's absolutely nothing wrong with going out and investing and making money, so long as you do it in an ethical way that complies with the law. And that you don't use information that should be kept privately for public good, especially if you're a public servant. So this deal between these two former schoolmates involved Mr Hill, who was the public servant at the Australian Bureau of Statistics, between August 2013 and May 2014, taking handwritten notes from unpublished labour force, new capital expenditure, retail trade and building approvals data, and sending that information to his mate Mr Kamei via his mobile phone. Why is this a very good example of how insider trading works? And can you explain the intersection between the public service and the market in this instance?
Thanks, Senator. So at the time, it was Australia's largest insider trading matter. As Chair Longo mentioned earlier today, in terms of our market supervision, we have a number of sources of information where we monitor market activity and particularly suspicious trading. In this particular case, I won't talk about the sources of information that we utilised, given their sensitive nature, but due to the size of the profits involved, that certainly alerted us to the suspicious trading. Within, I think, 24 hours of the matter coming to our attention, we involved the Australian Federal Police, and that's because we suspected the conduct was ongoing. We partnered with the AFP to use some of their covert powers, which we don't have, and in order to investigate the matter. Another reason for involving the Australian Federal Police is because the misconduct involved abuse of public office, so that under the Criminal Code involves, public servants misusing Commonwealth information. So
we've been talking about Commonwealth information in the last 48 hours around a potential intervention in the market to the tune of $4 billion that involved every major bank. And, of course, there's public interest in it. This was two young men. Hopefully they've seen the error of their ways and their lives have been reformed and they're on the path to a great life here in this country. But these two admitted to money laundering, identity theft and insider trading. That was the banker. And Mr Hill pleaded guilty to insider trading and misuse of public office. The information they were using was nothing of the scale of $4 billion as a market intervention. This was labour force data, new capital expenditure data, retail trade data, building approvals data. Yet they were sentenced, respectively, Mr Kamei, as I understand it, for 7 years and 3 months in prison, the person who used the information to the biggest financial gain of profit of $7 million. And Mr Hill was jailed for 3 years. The public servant who shared this information was jailed for 3 years and 3 months. So it was an effective investigation. It was pretty quick. You picked it up. Earlier, Mr Longo was saying to me that Asic took responsibility for doing this kind of work. In what year was that?
Senator, the sentencing, I think, occurred in 2015. From memory, I think the misconduct occurred
2013.
2013?
Yeah. So when did Asic pick up the responsibility from the ASX?
2010.
Right. So prior to 2010, you had no capacity to be involved in this. It was purely the ASX.
Senator, frontline market supervision was the responsibility of the ASX, and that was transferred. Frontline market supervision was transferred to Asic in 2010.
So the mechanisms that you talked about that triggered your attention to this, then your capacity to engage the AFP, the responsibility to be able to do that at the time that the GFC was on, and the $4 billion was inside market information that was absolutely known to Mr Gretchen being shared amongst the Liberal Party. What capacity would the ASX have had to engage the AFP if they had any concerns?
Senator, I can't respond to that. I'm not aware of that. It would be purely speculation.
Right. So perhaps we need to write to the ASX and find out what it is that they were doing, what techniques they were using, who they were engaging with, because it seems extraordinary to me that something of that scale wasn't absolutely on their radar and that they were using every tool possible to monitor that. Given also the interest in Mr Gretch, I wonder if the ASX then actually did due diligence and went back and had a look at what happened in 2008-9 around that period of time, given the public documentation around Mr Gretch's sharing of APS information. So can I ask you, just to conclude this line of questioning, is it concerning that the ASX have not taken any action with regard to Mr Gretch's publicly documented sharing of confidential government information to the Liberal Party? Unnamed numbers of the Liberal Party, but we've got an email trail of at least many.
Senator, I can't comment on those facts, as in those facts aren't known to me. And, these events occurred a long time ago. So again, it would be simply speculation to comment in 2025 on what the ASX did or didn't do at that time.
I think what's interesting, though, in your evidence is you're talking about an event in 2013-14, which is not that long after the GFC, where you had the wherewithal, the capacity, the systems in place to make observations. 2008-9 is not that far ahead of that. And I am becoming increasingly concerned that, given the public nature of Mr Gretsch's actions and his distribution of this information, that the ASX have not done anything with this, and neither have they referred it to you when it became your responsibility. So that is of concern to me. Could I just go directly to the ASX and new powers that you have? This is my last question, Chair.
Last question. Yep.
So the ASX has recently made rules in February 2025. ASIC has recently made rules in 2025, just this month, I believe, requiring the ASX to provide its clearing and settlement services on a transparent and fair basis, with a requirement to publish the comparison of fees against international providers. My understanding is this is a power that you have recently acquired and have used for the very first time, and I guess it follows on from your concern and concerns expressed by the Corporations and Financial Services Committee and this committee around the action of the ASX with regard to failure to deliver the CHESS program and the upgrade to their technologies. How will the new rules for clearing and settlement services that you've just issued support the development of a strong and innovative financial system? And how will these reforms that the government legislation and the rules have just issued help to limit the ASX's ability to misuse monopoly power and to deter new entrants?
I'll give a quick overall response, then I'll probably ask Commissioner Constant to amplify anything I say. That the reforms came out of the Council of Financial Regulators' recommendations back in 2015. They're basically competition in clearing and settlement powers rules that that legislation was passed last year, along with the market infrastructure reforms. They gave new powers to us and the Reserve Bank. So those two pieces of, just stepping back for a second, those two pieces of legislation, their origin was well before the whole CHESS saga that we've been talking about unfolded. Bringing back these rules are really significant because they're designed and intended to promote competition. The way they will work is if there's a dispute between the exchange and a market participant about what's being charged, then that can be effectively arbitrated by the ACCC. So the ACCC also gets some new powers or new role, if you like. This is an area of, if I can put it this way, of reform around the activities of the ASX that are really quite new. I mean, we've, as a legal system, we haven't really had the powers to really intervene on the competition side of things as we have now. And I think attitudes have changed as well within the market as to what's expected of ASX. Perhaps I could ask Commissioner Constant to sort of elaborate on what we expect to see happen the next 6 to 12 months. My understanding, though, is that the early impact of these rules won't be so great because they're primarily designed to bring down barriers to entry rather than... So at the moment there isn't a lot of competition, there aren't a lot of players, but we're hoping these new rules will encourage new players. Yeah. Can I ask Commissioner Constant?
So I think Chair Longo has outlined how this works and the background history. The only things to add are that probably the initial impact will be the confidence in the opening up of competition, and that this is a step change in the regulatory environment and oversight of ASX in that regard. So we hope that this encourages, whether it's participants in markets or people considering innovative other approaches, encourages them to continue exploring that and bringing those things forth.
There've already been expressions of interest, haven't there?
Yeah, and exactly, and there've also been responses, and that's the only other point to make, is that
there's been consultation, of course, in the lead-in. It's been carefully considered, including industry feedback, so which is about the balance, striking the right balance between the regulation, the cost of regulation, including, for example, independent assessments, versus really fundamental concepts like interoperability. So to enable that competition and the plumbing being able to work across and look toward the future. So the way that this has been approached in terms of taking up that consultation and feedback is also really important, and that's probably one of the initial impacts and signals.
Thank you very much.
Thank you. So the committee is now running around 2.5 hours behind. The committee's agreed to, after a final block of questioning from Senator Pocock, to move to the entire portfolio area that we haven't got to yet, being DISA. We've agreed to move to DISA and release Asic in 10 minutes' time. So, Senator Pocock, you have the call.
Risk. First, some questions about WiseTech. I understand that all the independent directors resigned on Monday and that Mr White has assumed the position of Executive Chairman and will now take charge of appointing a Chief Executive. Does ASIC think it's concerning that a single shareholder and executive can engineer effectively a takeover of a board at the expense of other shareholders?
It's certainly the case that we're very interested in what's going on at WiseTech and the extraordinary manoeuvres at board level. What I can confirm to the committee for today's purposes is that we have commenced some preliminary inquiries into what's going on there. Whether those inquiries will lead to the commencement of a formal investigation remains to be seen, but I can certainly reassure the committee that we're very interested in what's going on in WiseTech at the moment.
Thank you. Coming to mineral resources, is ASIC considering any action, or do you have any action underway in relation to mineral resources or its directors after recent governance issues surfaced there and the recent upset in its profit announcement?
Can you deal with it?
Good afternoon again, Senator Pocock. So again, I mean, it's a similar answer to the one that Mr Longo just gave in relation to WiseTech. Although in relation to MinRes, I can confirm that we have commenced a formal investigation in relation to the various issues that have been reported on in relation to that company.
And when you say various issues, can you give us some illumination about what they cover?
I think because we're at such an early stage, Senator, really where we're up to at the moment is looking at all the various media reports, receiving information from a range of sources and using our compulsory information gathering powers. And so, as is the normal course, we look at the conduct, we get all the information, we gather the facts and the evidence, and from there we will look at the particular contraventions of legislation that may arise. So we are really assessing the broad range of reports at the moment.
Are these two companies a lesson in why an independent and diverse board brings good governance?
Well, I might just refer back to Mr Longo's discussion with you earlier, Senator Pocock. I'm not sure I can add to that, but clearly in both of these...
Mr Longo's smiling now. I'd like to hear why you're...
Well, I think Deputy Chair Court's response is entirely appropriate. I'm not sure I've got much to add to what I said earlier. I think if I may say so, I've been around corporate issues my whole professional life, and there are just so many reasons why things go wrong in the boardroom. Clearly there's been some, I think I've been quoted on this publicly the last few weeks, there's been some personal misbehaviour, personal conduct that's unattractive of a wide nature, and that can, in the boardroom, can lead to trouble, can lead to governance issues. And I think we're seeing a bit of that at the moment. Now, whether that leads to, and I really want to be objective about this, actionable breaches of the Corporations Act that ASIC can do something about, that's a really different matter. Now, in terms of standards of corporate governance, I think it's really important we maintain the culture of talking about it, what we really expect of directors in terms of values and standards, and that needs to, and I think that's very healthy, and I think ASIC will continue to contribute to that, but we need to distinguish that from court action, where we have to have the evidence and be able to establish contraventions of our Corporations Act. That's a different, it's a different lens, if I can put it that way. Obviously very much related, but I just want to highlight from an enforcement perspective, going to court's a non-trivial exercise. Yeah.
And also, I would make the point, having sat through watching the internal culture and business model in PwC and in EY, where we saw major internal reviews of culture, which drove very poor practice. It's not something that you only find, of course, in the corporate sector. Other forms and structures face very similar problems with very significant costs. Your paper yesterday and your concerns about the private market and the way it's working, are any of the concerns about Mr Paul Chiodo and Keystone reflected in your concerns raised in that report, the one you released yesterday?
I think that's a stretch.
Okay.
That's the word that immediately comes to mind. I think the issues we're facing in the Shield master situation, if you don't mind, Senator, I will ask Sarah Court to remind the committee of some of what we already know about the issues we're facing in that matter and related matters. Because I think they're very serious for all Australians, the amounts of money involved, ordinary Australians being talked into doing things that really ought not to have occurred. That really is misconduct, and I'll ask Senator Deputy Chair Court to comment. Yeah.
I can be quick, Senator Pocock, given the committee's timing. Just a very quick reminder for the committee. So the Shield Master Fund is a registered managed investment scheme. Keystone Asset Management was the responsible entity for Shield. We have extensive concerns relating to the possible mishandling of significant superannuation monies that have been invested into that scheme, and we have taken a large number of investigation actions relating to a range of entities and individuals associated with the scheme. I think, Senator, I won't go into the particular entities and the particular individuals this afternoon, but suffice to say, we've taken multiple court actions to protect investor funds. We've frozen assets. We've obtained travel restraints. We've had receivers and managers appointed, and we are at the beginning, at the still likely early stages of what is an extensive investigation. We've stood up several teams of investigators to work on these matters, and the kind of figures that we're concerned about here, and these have been publicly reported previously, are sort of in the order of $480 million worth of investor funds and 5,800 investors potentially impacted. So it's a major issue. Unfortunately, that's not the only matter like this we have on our books at the moment, and we've been very keen to get out messages to say to potential investors in relation to their superannuation funds, be very cautious about transferring your superannuation funds into a self-managed super fund for the purposes of unrealistic property investment returns. These are industrial scale models that we are seeing.
Thank you for explaining that. Final question. Do you have underway or have you conducted any investigations in relation to the business operations of Mr Sanjit Gupta and his investments in GFG at Whyalla, InfraBuild or the Tahmoor coal mine?
I'll ask Deputy Chair Court. Obviously, the Whyalla situation's of great interest in unfolding. As to ASIC's role right now, I'll ask Deputy Chair Court to be as specific as we can.
Thank you.
Senator, again, I'll be relatively circumspect. We've been following very closely the situation that has emerged in Whyalla in recent weeks and months. Obviously, it's an issue of enormous import to the South Australian community. We have certainly made preliminary inquiries in relation to some of the financial reporting of some of there's a range of entities associated with Mr Gupta's group, and we're going to continue to continue to consider those governance issues going forward. I won't put it any higher than that at this stage.
And are you in contact with international bodies in relation to Mr Gupta's affairs?
I can't answer that with personal knowledge, Senator. I suspect some of our teams, I certainly know that they're considering the broad spread of companies that sit both within Australia and more broadly. Whether they are engaging with our overseas counterparts, I'm not sure at this stage.
Okay,
Thank
thanks.
you very
Thanks
much.
for all your answers.
Thank you, Senator Pocock. Thank you to Asic. That concludes the questions that we have for you, and you go with our thanks. Thank you. The committee will welcome representatives from DISA Program 1.1, and we'll take a brief recess while you come to the table.